Today's earworm comes from the Beastie Boys because, to paraphrase, Laura Loomer asked the court please, and they still said no. The U.S. Supreme Court said yesterday they are declining to hear conservative activist Laura Loomer's lawsuit against major social media companies, which include Facebook, which is of course owned by Meta, Twitter, which is now X, Google, and Apple. The decision leaves in place a lower court ruling that dismissed her case, effectively ending her years-long effort to claim that she was unlawfully deplatformed. Loomer is a far-right commentator and former congressional candidate and who has accused many platforms of many things, mostly conspiring to suppress conservative voices in violation of her First Amendment rights, particularly in antitrust laws for others as well. She claims that her 2018 bans from many places were politically motivated, and lower courts rejected this argument, saying private companies aren't bound by the First Amendment. Section 230. We'll get to that in a second. Now, the federal judge in Florida, where the case was heard later in the 11th Circuit Court of Appeals, basically ruled that Loomer and her company lacked legal standing under free speech or competitive claims, and emphasizing that the tech firms are really dealing with the now very controversial Section 230 of the Communications Decency Act. Now, what that allows them to do is not take any blame for other people's speech and can basically get rid of them because they don't want to take any blame for it. It's that simple. If someone's doing something that's offensive, pornographic, or just flat out ugly, they can get rid of it because it's not about free speech. It's about whatever makes them commerce. It works that way. The justice gave no comment in denying the review, which is a common practice. We're just not going to do it. No problem. Just push it away. The case arrives amid ongoing political fights over other social media bias, other state laws seeking to regulate platform moderation, and the court's upcoming review of the new content regulation cases coming from places like Florida and Texas. But we're not dealing with Loomer because we're just not dealing with her. The rejection ends Loomer's direct challenge, but doesn't settle the broader question of how, or actually whether, the federal law should actually change to curb tech platforms' control of speech. Congress remains divided on reforms in Section 230, which is a big deal, and the antitrust rules for social media giants. What Section 230 actually put into place, although maybe it was unintentional, maybe it was a protection from all these companies, tech companies, and folks in social media from any sort of responsibility for anything. People can say really ugly, nasty, stupid things online, and they don't get blamed for it. They don't get fined for it. They don't get taken down for it. But they can choose to get rid of folks that are, let's just say, a bit more on the annoying and going back and forth. But even those are changing in the way things are working in the administration we have right now. Now, upholding the current precedent is something that private platforms are happy about because the discretion they have over moderation, whether they want to do it or not, and who they want to do it for or to or not, is a big deal. Reinforcing the legal clarity and protecting online expression is a good thing. Whether these companies should have so much play is the question. Now, this also leaves frustrated critics and many folks like Loomer who want the court to bend to their will and give them the right to speak their minds and get paid for it, which is where things get there. Political bias and accountability is an issue for tech monopolies and the people doing public discourse. They are real issues that need to be addressed. Now, what is the issue at hand that will have to be addressed eventually will actually be what to do with Section 230. That's a whole other podcast for another day. But right now, we know that Laura Loomer has this court case squashed. She's still going to be deplatformed, or her deplatforming in 2018 has been upheld. Not much you can do about this one at this point.